Since I was last before Your Honor, Ms. Stockman and I have had conversations, and I believe the plaintiff and defendant, Barbara Stockman, are going to enter into a settlement agreement to resolve all their differences. So we will still need to move forward with the default judgment against Mr. Jackson. And then my goal, Your Honor, is to work with Mrs. Stockman between now and next Friday to have a settlement agreement signed, because the pending motion before Your Honor requires a stipulation from Mrs. Stockman to the relief we're requesting. And without getting into the details, I think what's going to happen is Ms. Stockman is going to convey the property to my client subject to the terms of the settlement agreement. We will then sell the property for an agreed upon amount, and any monies over and above the agreed upon amount and the cost to effectuate the terms of the settlement agreement will be paid to Mrs. Stockman, or, set into an account for her benefit, whatever she prefers.
Okay, so basically just hold off for today and then go forward with that, with kind of both defendants on the date of that you have set for default judgment.
Right, and I pushed that hearing out a little bit, Your Honor, because we mailed the notices and I didn't know if I was going to hear from Mrs. Stockman, and she called me right away. I asked her to call me, and she called me a couple days before that motion was filed. But I also have Mr. Jackson. I wanted to make sure he was served. I served him via priority mail, and as soon as we get the receipt back from the post office, I'll be filing that to make sure there's no service issues, because he's not participated at all in this proceeding.
Okay. Ms. Stockman, were you able to hear all of that?
Yes.
Do you have any objection to what Mr. Sadecki is suggesting?
No.
Okay. All right. So I'm just going to, for purposes of the status conference order today, I'm just going to indicate that case is going to proceed with a probable settlement with regard to Ms. Stockman, and then with default judgment against Mr. Jackson. Mr. Sadecki, anything else I can address for your side for the record today?
No, that'll cover it, Your Honor.
Thank you. Ms. Stockman, did you have any questions at all?
No.
Okay. All right. Thank you. That concludes the hearing for today, and all parties on this case are free to disconnect at this time.
Thank you.
Thank you, Your Honor. Have a good day.
Thank you. Okay, Mr. Blumberg, are you able to hear me okay?
Yes, I am, Judge. Thanks.
Okay. And do you have your client with you, or is he connecting separately?
I don't know that he's appearing. He's working out of state, so frankly don't know if he is or not.
Okay. All right. And Ms. Conklin, can you unmute, please?
Yeah, sorry about that. I thought I was unmuted. Good afternoon, Judge. How are you?
Good, thank you. Okay, so we're on the record now in Cruz versus Cruz. This is case number 2319351. Both counsel are present here today by Zoom. I see Ms. Cruz is also present. This is set for a status conference today. On behalf of plaintiff, Mr. Blumberg, can you give me an update on where things are at?
Sure, Judge. To be candid, there's some outstanding discovery that we owe to the defendant. I'm finishing up that and getting my client's signature. We're hoping that once the initial discovery is completed, we can go to mediation. I believe we've agreed on Jerry Sheffalo as a mediator in this case.
Okay, thank you. Ms. Conklin, on behalf of defendant?
Yes, that is true. We have still are waiting the verified financial information form. We provided all of our discovery requests, so that's the only holdup is our discovery right now. And I'm hoping it's going to be here soon. So this case doesn't drag out any longer than necessary.
Mr. Blumberg, do you have a timeline on those responses?
Sure. I mean, the verified statement form has been filled out, and I can email that to council today.
I've received that, but
Oh,
what I didn't receive, Mr. Blumberg, when you did send it, it was incomplete. We don't have the documentation that is required to be attached to that.
and I think I have that now, so.
Okay, and then my discovery request was due. I don't mind giving you an extension of time if you could give me an idea.
I'm hoping, as I told you last week, I thought I'd have it done by the end of last week. I'm still getting the documents for my client. Again, he's out of state, so that's delaying the process somewhat.
All right, so the court will order that mediation take place within the next 60 days. So Mr. Blumberg, whatever discovery responses should be provided as quickly as possible so that the parties can participate in that mediation. And then I'll set this for another status conference at about 60 days. Any objection to that, Mr. Blumberg?
No, Judge, that's fine.
Ms. Conklin?
No objections. Thank you.
Okay. All right, and I'm going to indicate, Ms. Conklin I just want to make sure is your understanding as well that Mr. Sheffalo is going to be the mediator?
Correct. That is, we have reached an agreement on that. My client was in agreement with that as well.
Okay, so I'll have that indicated. And then we'll go forward in about 60 days. If the parties are ready to enter judgment at that time, we can use that date to take proofs and enter the judgment. And if not, we can see what we need to do to schedule to get things wrapped up. Mr. Blumberg, anything else I can address for your side today?
No, Judge, thank you.
Ms. Conklin?
No, Your Honor, that takes care of it. Thank you.
All right, thank you. That's all for today, and all parties are free to disconnect on this file.
Thank you.
Okay, looks like we have both counsel connected. We'll go on the record in L&L Contracting versus CST Construction. This is case number 2319221. If I could have both counsel put your appearances on, starting with plaintiff.
Good afternoon again, Judge Elliott Blumberg on behalf of the plaintiff.
Good afternoon, Mike Meadows on behalf of the defendant, Tad Uzek, who may be signed in on Zoom, also wants to participate.
Okay, it does look like Mr. Latuzak is connected. We're on the record for a status conference today. And it looks like the last time we met was back in September or October. Mr. Blumberg, can you, from the plaintiff side, give me an update of where things are at?
Sure, Judge. The matter has been resolved. Settlement has been reached. I just need to prepare the closing documents, but pending that, the case can be closed.
All right, thank you. Mr. Mataloni?
That's correct. Mr. Blumberg has agreed to prepare the settlement paperwork and also to reach out to the prosecutor's office and let them know that my client has satisfied the $10,000. My client also paid $2,000 in restitution to the courts during the pendency of that. That's also going to be awarded to the plaintiff. Whatever restitution he paid, that has already been paid to the plaintiff. We're not disputing that monies. So, and I understand the entire civil case will be dismissed. So I think it resolves everything.
Okay, Mr. Blumberg, when do you think you'll be able to submit the dismissal documents?
I just got the settlement proceeds today, Judge, so I would hope to have it done in maybe 10 days or less.
Okay. Sounds good. Thank you. Mr. Blumberg, anything else we need to address for the record from your side?
No, Judge. Thank you very much.
Mr. Mataloni?
No, sir. Thank you very much.
Okay, thank you both for connecting today. All parties are free to disconnect at this time.
Thank you. Have a good day, everyone.
All right, hello, we've got somebody on the phone with the last four digits of 3114. Can you tell me your name, please?
Jack Turner.
Okay, and Mr. Turner, are you calling in on Town versus Gaylord Big Boy?
Yes, sir.
Okay. We're on the record then in Town versus Big Boy, case number 2219071. And Mr. Turner, you're representing the plaintiff, is that correct?
Yes, Your Honor.
Okay. And I believe this was set for a debtor exam today. And Mr. Turner, has the debtor appeared? Have you had contact with the debtor in this case?
I talked to their lawyer on Friday and he said they were not going to appear.
Okay. So obviously you issued a subpoena for them to appear. How did you want to proceed today then?
I guess I wanted to see if we could reschedule this and also see if they would pay a couple hours of my time for coming down here.
Okay. So I guess what I would suggest, Mr. Turner, if you want to contact my office and have this set for a debtor exam hearing, as well as a show cause for their failure to appear pursuant to your subpoena today.
Okay.
Then we can have them respond and see where we go from there.
Okay.
But I will note for the record and I will note for the record that they did not appear today. And then, like I said, just call my office and get a date for that hearing and show cause.
Okay, I will do that.
Okay, thank you. Anything else I can address for your side today?
That's all, Your Honor. Thank you.
Okay, thank you. You're free to disconnect at this time.
Thank you.
All right, Mr. Gold, are you able to hear me okay?
I can, Your Honor.
All right, we're on the record in Robertson versus Robertson. This is case number 2319417. And I do not see your client, Mr. Gold, in the waiting room, and I don't see Mr. Robertson either.
I spoke with them on the phone, Your Honor, about 15 minutes ago. They are together using the same laptop, and it was my understanding that they would be here. So if you'd like, I can call them. Well, they do have a settlement. I thought we could put that on the record as well as take proof. So I can give them a call real quick if you'd like.
Yeah, that sounds good. And I'll just put you in the waiting room for just a short minute while you do that, and then I'll bring you back in, and hopefully them as well.
Certainly, thank you. One quick button they need.
Looks like they're connecting. Here we go. Okay.
Yeah, sorry about that.
All right. That's okay. So we're on the record now in Robertson versus Robertson. This is case number 2319417. We have Mr. Gold present by Zoom video on behalf of Ms. Robertson. Both parties are present by Zoom video as well. Mr. Gold, you indicated you believe there may be a resolution to this case.
Yes, Your Honor. I think that the parties have come to an agreement on everything. We just need to have that drawn up and signed. And one of the agreements is that the judgment would not be entered until after the first of the year. So we have a little bit of.
All right, Miss Robertson, is that correct from your standpoint?
Yeah,
And Mr. Robertson, do you agree with that?
Yes, Your Honor.
Okay, so then Mr. Gold, you wanted to take proofs from your client today?
Yes, please.
All right, Miss Robertson, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes,
Thank you. You can lower your hand, and Mr. Gold, proceed whenever you're ready.
Thank you. Ms. Robertson, can you state your full name for the record?
Annette Francis Robertson.
And Ms. Robertson, are you currently married to Scott Robertson?
Yes,
And you were married on or about August 21st, 1986?
yes,
And then prior to filing your complaint for divorce, had you been a resident of Otsego County for the previous 10 days?
yes,
And had you been living in Michigan for the previous 180 days?
yes,
And you and Mr. Robertson have no minor children at this time, correct?
correct,
And you are not currently pregnant?
correct.
Has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed?
Yes,
Does there remain any reasonable likelihood that this marriage can be preserved?
no,
As far as you're aware, your agreement that you want to place on the record today, your agreement for the divorce is that your marital home will be listed for sale in March of 2024. Is that correct?
yes,
And then once it's sold, you will share the profits or the debts equally with Mr. Robertson?
correct,
And then also after the house has been sold, you will then divide all retirement accounts owned by both parties and all liquid assets.
correct,
And then also, as far as vehicles, you are to receive the 2020 Terrain, and Scott is to receive the 2012 Traverse, the 2003 truck, the golf cart, and the lawn tractor. Is that correct?
correct.
Do you believe that that's a fair and equitable split of all of the marriage debts and assets?
Yes,
I have no further questions, Your Honor.
Thank you. Did you want to take any testimony from Mr. Robertson, Mr. Gold?
Yeah, we can, just briefly.
Okay, Mr. Robertson, could you raise your right hand, please?
Yes, sir.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand, and Mr. Gold.
Thank you. Mr. Robertson, you just heard what I kind of outlined as your guys' agreement for the divorce. Is that correct as to your understanding, or did I miss something?
No, I believe it's correct.
And you believe that's a fair and equitable division of the marital assets and debts?
That's how we're trying to keep it.
All right. I have no further questions, Your Honor.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of the parties. The court will grant the divorce. However, Mr. and Ms. Robertson, as I'm sure you're aware through Mr. Gold, the divorce isn't final until that judgment is submitted and the court signs it. So I understand that you have some agreements about when that's going to take place, but just make sure that you follow through with that last step with Mr. Gold, because it's a very important and critical step to finalizing matters.
yes,
Other than that, Mr. Gold, I'm just going to indicate for the file that you're going to submit the judgment after the first of the year in January.
That's perfect. Thank you, Your Honor.
Okay. Mr. Gold, or Mr. Robertson, do you have any questions?
No, I do not.
Okay. Ms. Robertson or Mr. Gold, anything further from your side?
nothing from me. I'm all set.
We're all set. Thank you.
Okay, thank you. All parties on this case are free to disconnect at this time.
Mr. Gold, he's gone.
Well, it looks like he already disconnected.
Yeah, we can talk to him later.
Thank
Sounds
you.
good. Thank you.
Thank you, Judge Mertz.
Thank you. Right. Mr. Carey, are you able to hear me all right?
Real well, thank you.
Okay. And we have Mr. Dunn connecting right now.
I drove through Gaylord last night at about 8 o'clock on my way back from the UP. And of course, I was pulling a trailer. It was quite an experience.
We got a lot of snow yesterday.
Yeah.
I think I'm in now, gentlemen.
Okay, good. All right, excellent. We'll go on the record in Lampkin versus Wiley. This is case number 2018296, consolidated cases. And let's see if I can have just counsel put your appearances on, starting with plaintiff.
Robert Dunn appearing for all of the plaintiffs.
And Your Honor, William Carey appearing on behalf of the defendants, and we are the moving party.
Okay, this is set for hearing today. Mr. Carey, you did file a motion for entry of a final judgment. I did have a chance to review that along with the attachments. Is there anything that you'd like to present today by way of argument?
Really nothing more than what's laid out in the motion that the court has reviewed. I do see, though, that I didn't. Oh, I see why I didn't. We filed our motion on about the 11th of September. On the 18th of September, so about a week later, we received 4 orders from the Court of Appeals that denied plaintiffs' application for leave to appeal. And that probably should be noted for the record. So currently, to my knowledge, no portion of this case is pending in the Court of Appeals. And again, Your Honor, our motion, I think, sets forth exactly what we're looking to accomplish today.
All right, thank you. Mr. Dunn?
Yes, Judge. I did not file a response to that motion on the particular issue you're interested in because, frankly, I don't believe there's any case law that says that we are entitled to money damages for this. But there isn't any case law that says that we cannot get, that we are barred from getting money damages for this either. So it's a bit of a strange situation. So I really can't give you a controlling authority that says I'm entitled at this point to a jury trial on money damages. We, of course, do need a final order. Your temporary injunctive order, the 30-day time provision seems to work real well. I think there was another case that came down that I saw that had a 6-month provision in there. I don't know if Mr. Carey saw that one. It came down recently from the Court of Appeals. But we do need a permanent order that basically says that you cannot do the short-term rentals if there are the deed restrictions, unless you are using your home as a residence. And that's, of course, been our position all along.
Brief response to that, Your Honor?
Yes.
So I think both counsel and I have been consistent, albeit not with each. We've been consistent in our view, but our respective views differ. Your Honor, I did a very exhaustive analysis in its opinion, determining the scope of the relevant deed restriction and what it allowed and what it didn't allow. Your Honor then went a step farther, I think, in an effort to bring relative calm to the subdivision while the case was pending, and entered a temporary injunction that didn't attempt, and your honor made it clear that you were not attempting to match, if you will, the analysis of your order on cross motion for summary disposition to the injunctive order, but rather wanted to use the temporary injunction. Again, I think the best way to describe it is to bring calm to the neighborhood. Your honor's opinion on the scope of the deed restriction is very clear. It was a kind of a balancing of a variety of factors, and the opinion does make it clear that not all short-term rentals are prohibited by the deed restriction. So while I appreciate the simplicity of a permanent injunction that mirrors the preliminary injunction, it's not what the courts ruled. So that's why I propose that a final judgment declaring the scope of the restrictions using verbatim the language in your opinion and order on summary disposition that was entered, gosh, I can't even believe this, May 26th of 2021, that we take that language, that we enter a final judgment of declaratory relief, which defines the rights of the relative parties within the subdivision. And then to the extent, and so before the court made that ruling in May of 2021, it is fair to say that nobody had an idea what that deed restriction meant, or everybody had an idea of what that deed restriction meant, but nobody agreed on what it meant. Well, now we would have a final judgment of declaration of rights. And of course, I think it would behoove everyone to have that order, that final judgment recorded in the chain of title. So all lot owners are on notice of it. The world indeed is on notice of it. And then if renting occurs in violation of the scope as defined by that final judgment, as defined by your May 26, 2021 order, then parties are way ahead of where Mr. Dunn and I were when we started this case. And that's why I propose what I propose here. A preliminary injunction, permanent injunction that mirrors the preliminary injunction, just it would contradict your opinion and order of 2021.
A very brief response, Judge.
Yes.
Again, the only thing I would add to that is we're bound by the O'Connor decision of the Michigan Supreme Court. You can only have, if there are deed restrictions along the lines of what we have here, can only have the short-term rentals if the owner of the property is using the property as a residence. That's what O'Connor says. We have to follow it. Many of the other things that Mr. Carey said are fine with regard to what's in the final order.
All right. So I had a chance to go through everything in anticipation of today's hearing. I do think that a final judgment is appropriate at this time. I think the issue is what does that look like and what is in it. I've got some ideas in that regard, and I've already started drafting a final judgment, but I wanted to hear from both sides today before I did that. And I think it's in everybody's interest going forward to have that in writing. And again, I think the language of that is going to be really crucial to both sides going forward. So I want to make sure that I'm careful in how that's drafted. And part of that was making sure that I heard from both of you today. So the court is going to issue a final judgment. I'm going to do that. I like to use the word forthwith, so as quickly as possible, so that both sides have some certainty going forward, whether that's for appellate purposes or just practically going forward in the subdivision. So I agree in principle that there needs to be a judgment entered. I think it's time for that. The court again just wants to be very deliberate in what is in that judgment. So I'll provide that to the parties as quick as possible. I appreciate both of your positions here on the record today. It is helpful to the court. And that's all I have. Mr. Carey, anything, or I'm sorry, Mr. Dunn, anything further on behalf of plaintiffs today?
Just that this may be our last hearing. I enjoyed doing this litigation with you gentlemen for all this time. Thank you for the courtesies you both have shown. Mm-hmm.
And thank you, Mr. Dunn. I appreciate your time on this as well, and you as well, Mr. Carey.
You bet. Thank you both.
Thank you. All right, just waiting for one more party to come online here. Okay, looks like we've got everybody connected, so we'll go on the record in McFan versus Powell et al. This is case number 2218941. We do have Mr. and Miss Powell present by video. We have Mr. and Miss Brianna also present. We have Mr. Blumberg present on behalf of Jam Exploration. This was set for hearing at 2:30. I don't see Mr. McFan connected, which is unusual. Mr. McFerrin's always been present for prior hearings as plaintiff. This is set for a status conference today. If everybody recalls, we had a hearing back in October on some motions in this file as well as the related files. The court is in the process of finishing written opinion and order that would apply to this file along with all the other ones. That's not been issued, but that's forthcoming here shortly. So I don't really have anything to address. I think this was set for hearing prior to that. So I don't have anything to address with the parties other than to recognize that everybody has appeared today other than Mr. McFan. Mr. Blumberg, on behalf of Jam Exploration, is there anything that you wanted to state for the record?
Judge, again, my recollection is that was Mr. McFerrin's motion to disqualify the court?
Correct.
Okay. I know that from our perspective, we are in the process of drafting a summary disposition motion that I think would resolve the claims against my client, but obviously we can't do that until you rule on that prior motion.
All right, thank you. Mr. Powell or Ms. Powell, anything that either of you wanted to say for the record today?
Well, I think it's only proper, Your Honor, that I think this is the 8th hearing since May that we've had regarding this issue. I have been present for every hearing. I think there should be a legal standard that the plaintiff should be present if he's that serious in his claims. And I know with last hearing, I filed a motion for dismissal. I do not know what the court had ruled on that, being that it's not filed yet. But I think that if Mr. McFan has not made attempts to be here present today, I think it may be necessary to file a motion for dismissal based on his failure to show, if I had to do that again.
And again, I am noting for the record that he's not present, and that is a potential avenue that you could pursue, Mr. Powell. So
Thank you.
I do note that for the record. Ms. Powell or Mr. or Ms. Brianna, anything that either of you wanted to state for the record today?
No.
Your Honor, can I do the same process like my husband does? Like with this finishing this case because, I mean, from what I read in the case, what Mr. McFerrin's have against me, it's complete lie. So he blamed me in beating him. So I never touched this person even like with the tip of my finger. So I mean, I didn't see any sense of continue me present on this hearings and continue this case for which already like for 2 years.
And I understand, unfortunately, I can't give you legal advice. I can't tell you whether you can or can't do that or whether you should or shouldn't do that.
Mm-hmm.
All I can say is that Mr. McFerrin is not present, and that may be something that you and your husband want to explore as a potential avenue of relief, but I cannot give you legal advice on how to do that or what to do that.
I understand. Thank you, Your Honor.
Either way, as I said, the court's going to be issuing an order in this case shortly, and that'll also provide guidance to all parties going forward as well, including Mr. McFerrin. So thank you everyone for being present today. All parties are free to disconnect at this time.
Thank you, Your Honor.
Mr. Blumberg, just as a side note, do you have, I believe you have the 245, so.
I do.
I'm just going to put you on hold briefly, and then once Mr. Dundon connects, I'll bring both of you in on that one.
Great, thank you.
Okay, we'll go on the record in Tronic versus Tronic, case number 2219141. If I could have counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Mark Dundon appearing on behalf of Leanne Tronic.
Good afternoon again, Judge Elliott Blumberg on behalf of Donald Tronic, the defendant who's appearing from my office via Zoom.
All right, the court set this as a final status conference. We currently have this set for a one-day bench trial on January 19th, but just before the court leaves that on its docket, just want to make sure that the parties still intend on proceeding forward. Mr. Dundon on behalf of plaintiff.
Yes, Your Honor. At this point, I don't think we've settled. I'm hoping that there's a small possibility if we send some more back and forth stuff that maybe we could, Your Honor, but for now we don't have a settlement.
All right, Mr. Dundon, from plaintiff's standpoint, other than what we discussed last time in terms of just exchanging witness and exhibit lists and submitting the trial briefs to the court 7 days prior to trial, are there any issues that you anticipate the court needing to address before the day of trial in this case?
No, Your Honor, those would be the three things we need to get in that should do it.
All right, thank you. Mr. Blumberg, from your client's standpoint.
There is certainly an issue of separate property, Judge. The marital home, which was owned by my client prior to marriage, I don't think there's any dispute as to that, but that's an issue that is also somewhat holding up a resolution of this matter. So we continue to talk, but we haven't really even received a settlement proposal regarding the division of the residence, which is the major asset of the marriage. So we're happy to keep talking, but it doesn't look like we're making much progress.
Okay, so the court will leave the trial date set for one day. Again, that's set for Friday, January 19th. So I'll plan on proceeding. Counsel and parties are ready to go at 9 a.m. Again, I will just ask that counsel submits a trial brief to the court about 7 days prior to that date, outlining those kind of legal issues, Mr. Blumberg, that you mentioned, and so that the court has some idea of what we're going to be addressing throughout the proofs that day. If the parties for some reason are able to resolve it prior to that, if one of you will notify the court, we can use that time at 9 that morning to take proofs, or do it earlier if the parties want to try and get it set earlier. Otherwise, we'll proceed on the 19th. Mr. Dundon, anything further I can address for your side today?
No, Your Honor.
Mr. Blumberg?
No, Judge, thank you.
Okay, thanks for your time today, counsel, and we'll see you on January 19th. Parties are free to disconnect. All right. Mr. Dible, I'm going to need you to go into your Zoom app and connect your audio. There we go. All right. Mr. Dible, are you able to hear me okay?
Yes, sir.
And Ms. Stanko, are you able to hear me okay?
Yes, sir.
Okay, so we're on the record in Dible versus Stanko. This is case number 2319454. The record should reflect both parties are present today by Zoom video. This is set for a pre-trial hearing. Today, my goal is to find out whether or not there are any disputes between the two of you in terms of dividing up any assets or debts of the marriage, or whether we're ready to go forward and just finalize things. So, Mr. Dible, from your standpoint, are there any matters that need to be decided by the court, or have you been able to agree with Ms. Stanko?
No, sir. We're good. I'm good. Thank you.
Okay, Ms. Stanko. Ms. Stanko, what's your thoughts on that?
I'm good. Yep. There's no issues on my end.
Okay. All right. So the only thing we need to do going forward then is set this for a final hearing to finalize the divorce. Mr. Dible, did you get your forms online to file for the divorce in this case?
I had received everything from Ms. Stanko. I received all the forms, I believe, and filed everything from online and gave them to the county clerk.
Okay, so there's one more document. It's in that same place where you guys got the filing documents. It's called the judgment of divorce, and that's the final form that you need to fill out. That's the last thing that the court signs to finalize the divorce. So if you guys can fill that out, sign that, and then submit that to the court prior to that next hearing. Then I just have to take some brief testimony from both of you to establish the grounds for divorce, and then I can sign the judgment, and that'll finalize things. So that's really the only step that you need to do before that next hearing. Mr. Dible, did you have any questions about that?
I do not know, sir.
All right, Ms. Stanko, did you have any questions about that at all?
No, sir.
Okay, so as long as you do that before that next hearing, we'll be able to finalize things then. The court will send you a notice of the date and time, just like for today's hearing. And it'll be by Zoom, just like we're doing today. Any questions at all, Mr. Dible?
No, sir.
Ms. Stanko?
No, sir.
Okay, thank you then. Just look for that hearing date in the mail, and again, submit that final judgment of divorce form, and you're both free to disconnect.
Thank you, sir.
All right. Counsel under Don, can you tell me your name, please?
Yes, sir. Ryan Charles, here on behalf of Emily and William Holowinski.
Okay. We'll go on the record in J&J Construction versus Holowinski, case number 2319260. Mr. Charles has already put his appearance on. Mr. Benzinger?
Yes, thank you, Your Honor. Brad Benzinger on behalf of defendant J&J Construction.
Okay, so I did have a chance to review the party's motion for summary disposition, which is what we're set for today. Frankly, I probably should have noticed it when we had our pretrial hearing, but I didn't. And Mr. Benzinger's client, J&J Construction, the Jeffers family, they're friends of ours. Our kids go to school together. Mr. Jeffers and I travel in the same circles, and I've actually, I've referred his business to some friends to do projects for them. So the court's going to disqualify from this case. I don't think it'd be appropriate for me, given the contacts that I have with the Jeffers family socially, to make substantive rulings in this case. So I was going to have my assistant contact you both prior to the hearing today, but I thought it'd just be easier to place it on the record. Mr. Benzinger, anything that you wanted to state for the record?
Nothing, Your Honor.
All right, Mr. Charles?
No, Your Honor. We obviously trust your judgment in the disqualification, so appreciate you raising that. I guess just logistically, would this be assigned to Judge Hunter, or what would be the?
Right, if first we'll go to Judge Hunter. Just facially, I don't think there's anything that I can see where a basis for him to disqualify, but he'll take a look at that if, and if he can't hear it, then it would be referred out. But as you both may know, Judge Hunter, we're in the same circuit, but he lives in a different county and different circumstances there. So, but the courts signed the disqualification order, so it should be processed relatively quickly, and hopefully it won't delay hearing your motion too much beyond today.
Very well. Thank you, Your Honor.
Okay, thank you. And both sides are free to disconnect at this time.
Thank you.
Good afternoon, everybody.
All right, hello. We are on the record in Beckman Production Services versus Michigan Kenworth and Ron's record. This is case number 2319404. And if I could have counsel put your appearances on, starting with plaintiff.
Good afternoon, Judge Paul Slough on behalf of Beckman Production Services.
Good afternoon, Your Honor. Christian Idlam here on behalf of defendant Michigan Kenworth.
Good afternoon, Your Honor. Mark Mueller on behalf of defendant Ron's record.
All right, thanks for being on today, counsel. Mr. Slough, on behalf of plaintiff, we're set for just a scheduling conference in this case today. Can you just tell me a little bit about what your claims are and what kind of dates that you would like to see the court set going forward?
Sure. Yeah, the case generally is about the destruction of a tractor trailer that my client was having refitted by Michigan Kenworth to be used in the oil and gas industry. It's sort of a special outfitting that needs to be done to use it off-road. And in the course of doing that outfitting, Michigan Kenworth had to have it relocated to a Grand Rapids facility, and it hired Ron's Wrecker to do that towing of the vehicle. During the towing, the vehicle caught fire. and there's a dispute between the defendants about what exactly was the origin of that fire, how it came to be. But unfortunately, the vehicle was a total loss. So it's a negligence claim against the two defendants.
Okay, what kind of scheduling are you looking for going forward here?
I think probably for discovery, maybe 5 months would be appropriate. Witness and exhibits, 60 days is probably fine.
No objection.
Okay.
Yeah, I have no objection.
Okay, all right. Mr. Mueller, Mr. Odlum, did either of you, anything that you wanted to say just regarding your general positions? Anything unique or particular about this case that the court should be aware of in terms of scheduling that might affect scheduling?
No, Your Honor, I think Paul did an excellent job of giving a synopsis of the case, and I think 5 months will be adequate for us to get discovery done in this case. I would support mediation over case evaluation. I'll let the others chime in on that.
Yeah, I don't have anything to add, Judge. And we're always good with mediation.
Yeah, I agree to mediation. Some facilitative mediation would be appropriate. My understanding, and counsel can correct me if I'm wrong, my understanding is that the defendants in the case have already had experts look at the vehicle and render some opinions. So I think most of the discovery is going to be sort of figuring out those opinions and trying to reconcile them. And once we get through that, then the case would be ready to mediate.
Okay. Do you think that you guys will all be able to agree on a mediator?
I would hope so.
Yes.
Okay. Okay, so the court will set aside 5 months for discovery. Preliminary witness and exhibit lists will be exchanged within the next 60 days. I am going to request that mediation take place at some point during that 5 months for discovery, earlier or later, depending on when you, the attorneys, all think it would be most helpful. But I am going to request that within the next 14 days, that you all confer and try to agree on a mediator. And if you're able to, if you can notify the court of your selection in writing, so that we can get that process going. Is there any objection to the court setting a dispositive motion cutoff for 30 days after discovery?
No objection.
No, Your Honor.
No, Your Honor.
Okay. And then I will set this for a status conference right around the close of discovery, just to kind of see where things are at, and what kind of scheduling we may need to do going forward from that point if the case hasn't settled or otherwise been disposed of. Mr. Slough, on behalf of plaintiffs, any other dates that I can address for your side today?
I don't believe so. Thank you.
Mr. Odlum?
No, Your Honor. Thank you.
Mr. Mueller?
No, Your Honor. While we're all here, I'll just invite Paul to throw out some mediators' names. And then Christian, I would ask that maybe you confer with your local counsel, Tom Hackney, in regards to any names you may not recognize.
I try to stay away from Tom Hackney as much as I can.
I totally get it.
Okay, that's all I have. We'll put these dates into an order and get that out to the parties. Thank you.
All right. Thanks everybody. Have a great night. Thank you.
Happy holidays.
You too.
Here we are.
Hi there. On the Samsung device, can you tell me your name, please?
Shandy Wells.
Okay, 1 second. All right, sir, are you Michael Wells?
Yes, sir.
Okay, we're on the record now in Wells versus Wells. This is case number 2319439. The record should reflect that both parties are present today by Zoom video. I have this set for entry of a default judgment of divorce. And Mr. Wells, you submitted a proposed judgment here. Is that how you wanted to proceed today?
Yes.
Okay. And Ms. Wells, do you have any objection to proceeding with finalizing the divorce today?
No, I don't.
Okay. All right. So Mr. Wells, I'm going to have you raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Wells, as the party filing for divorce, I've got some questions to ask you. These are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. So my first question, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes, sir.
At the time you signed that complaint, have you been a resident of the state of Michigan for at least 180 days?
Yes, sir.
Had you been a resident of Otsego County for at least 10 days?
Yes, sir.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No. Oh, well, we have children, but they're not minors.
Okay. They're all over the age of 18?
Yeah. Yes, sir.
Okay. Under the proposed judgment, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
And under the judgment, you would be responsible for whatever debts are in your own name, and you're going to keep whatever personal property you have. Is that correct?
Yes, sir.
And you don't own any real estate or real property with Ms. Wells?
No, sir.
Okay. Thank you. Ms. Wells, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Thank you. Ms. Wells, did you hear all the questions that I asked Mr. Wells?
Yes.
Did you hear all of his answers?
Yes.
Do you have any reason to believe that any of the answers he gave were not true?
No. They were all true.
Okay. Are you currently pregnant?
No.
And under the judgment, you also would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and you would not be able to come back later and ask the court for that.
Yes.
Are you asking to have your last name changed?
Yes.
Okay, what would you like that changed to?
Tapley.
Can you spell that for me?
Tapley.
Oh, thank you. All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce, and I'm signing that judgment. Ms. Wells, because the court's signing the judgment of divorce today and your divorce is final, that means that your name will legally be changed from today forward to Tapley. So if you want, you can contact the clerk's office here about how to get a copy of this judgment, because you'll need that to change your name on your identification and other documents, okay?
Okay, thank you.
Mr. Wells, did you have any questions at all?
No, sir.
Ms. Tapley, did you have any questions?
No, sir.
Okay, thank you. That's all for today, and both sides are free to disconnect at this time.
Thank you.
Thank you.
Okay, let's see. All right, ma'am, if you can unmute, can you tell me your name, please?
Roberta Brown.
Ms. Brown, okay. Mr. Brown, if you can unmute, please. All right, thank you. Sir, are you Richard Brown?
Yes, I am.
Okay, we're on the record in Brown versus Brown. This is case number 2319448. The record should reflect that both parties are present today by Zoom video. The purpose of our hearing today is a pretrial hearing in this divorce action. And the purpose is for the court to find out whether or not there are disputes between the two of you regarding any division of any assets or debts of the marriage, and whether we need to set further hearings or whether we can just set this to finalize the divorce. So Ms. Brown, as the filing party, have you been able to reach any agreements with Mr. Brown? Are there any matters in dispute?
There should be no matters in dispute.
Okay. Mr. Brown, do you agree with that?
I do.
Okay. So what I can do is set this for a final hearing. At that hearing, the court will take some brief testimony from each of you. That's the testimony I need to take to establish the grounds for divorce under Michigan law. Prior to that hearing, Ms. Brown, as the filing party, there's one other form that you may already have it, you may have gotten it with your forms to file for divorce in this case. But there's one more form, and it's called a judgment of divorce. And
Okay.
that's the final. Go ahead, sorry.
Oh, I'm sorry. I don't think I received it, but I could go get one from the courthouse.
Yeah, or you can print it off online as well.
Okay.
So there are various places where you can find that, but it's called the judgment of divorce, and that's the final document to wrap up the case.
Okay.
And so I'm going to need you to submit that before that final hearing.
Okay.
The court will send out a notice of the date and time of that hearing, just like we did for today's hearing, and it'll also be Zoom just like today. Okay. And then again, Ms. Brown, as long as you submit that form prior to that hearing, then we can finalize the divorce on that date, and it should be in about 30 days.
Okay. I can definitely get that paper filled out and turned back in.
Okay, great. Ms. Brown, did you have any questions at all?
Nope, I think that's it.
Mr. Brown, did you have any questions?
No, I don't.
Okay, thank you. That's all for today, and both sides are free to disconnect at this time.
All right, thank you.
Okay, Mr. Brandenburger, if you can unmute, there we go. Sir, is your name Jeremy Brandenburger?
Yes, sir, it is.
Okay, we're on the record in Brandenburger versus Brandenburger. This is case number 23-19373. And Mr. Brandenburger, hold on one second. All right, Ms. Campfield, are you appearing on behalf of Mr. Brandenburger today?
Good afternoon, Your Honor. I think I'm connected.
Yes, are you able to hear me?
I can, thank you.
Okay, we're on the record now in Brandenburger versus Brandenburger. And Ms. Campfield, you're appearing on behalf of Mr. Brandenburger, is that correct?
That is correct.
Okay, I have this set for entry of a default judgment of divorce today. Is that how you wanted to proceed?
Yes, that is accurate.
Okay, I did have a chance to review the file in this case. It does appear that Ms. Brandenburger was defaulted back in September. So I can place your client under oath if you want to take proofs.
Yes, that would be fine, Your Honor.
Okay, Mr. Brandenburger, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, Your Honor.
Thank you. You can lower your hand, and Ms. Campfield, please proceed when you're ready.
Well, thank you, certainly. Mr. Brandenburger, did you file a complaint for divorce with the Wealthy Street Law Firm in the county of Otsego on or about July 14th of 2023, sir?
Yes, ma'am, I did.
And at the time that you filed that complaint for divorce, had you resided in the state of Michigan for over 6 months and in the county of Otsego for over 10 days prior to filing?
It's complicated, ma'am. My HOMA record was never switched to Otsego County. I was deployed overseas and was unable to perform a change of address. But since the filing of divorce, I have been in Otsego County for longer than 10 days.
Okay. But before the filing, you've always resided in Otsego County before you were deployed?
Yes and no. So originally I was down in Battle Creek, and then my wife moved up to Otsego County to live here while I was deployed.
All right. So at least one of the parties, that being Adriana Brandenburger, resided in Otsego County for 10 days prior to your filing of the complaint.
Yes, ma'am.
And then you relocated there as well.
Yes, ma'am.
Thank you so much for that clarification. It's my understanding that we also filed a proof of service of that complaint and summons upon Adriana, and she failed to file an answer with this court. We did get a notice of default entered by the court on September 13th of 2023. Is that your recollection as well, sir?
Yes, ma'am.
And prior to filing the divorce, obviously this is a silly question, but we have to ask it. You were married to Adriana Brandenburger by someone who was lawfully able to perform marriages. Is that true?
Yes, ma'am.
And in your complaint for divorce, you allege that there was a breakdown of the bonds of matrimony to the extent that those could no longer reasonably be preserved, and requested that this court enter a divorce for you. Is that true?
Yes, ma'am.
Were all the things that you alleged in that complaint for divorce true at the time that you filed it?
Yes, ma'am.
Do they remain true today, sir?
Yes, ma'am, they do.
And to your knowledge, my office did file the proposed judgment of divorce on with the court and serve it to Adriana as well, so that she would know that this hearing was moving forward. Is that true?
I believe so, ma'am. Yes, ma'am.
Yes. And we've served on the court a default judgment of divorce that requests that the marriage be dissolved and a divorce be declared, that neither party will have a spousal support award, meaning you won't pay her, she won't pay you. There's no real property to divide. The personal property has already been divided to the extent that each of you will keep what's in your current possession, and you will have the Chevy Colorado, and she will have awarded to her the Dodge Dart. Is that accurate thus far?
Yes, ma'am.
And that there will be no division of any retirement. You will each keep your own. Is that true?
Yes, ma'am.
And that any debts that each of you had in your individual name will be retained by yourselves individually, meaning she keeps her debt, you keep yours. True?
Yes, ma'am.
All right. And you agree that you will be bound by this judgment of divorce and help the my office or any other parties to execute its terms once it's signed and entered by the court.
Yes, ma'am.
And you don't have any children together with Ms. Adriana Brandenburger.
That is correct.
And to the best of your knowledge, Mr. Brandenburger, is she pregnant currently?
Not to my knowledge.
All right, thank you. And you agree that you could have had an opportunity to go to trial had she answered this and it been scheduled the same, but you're agreeing to waive that right to trial and allow the court to enter this default judgment of divorce as it's been presented by my office, sir?
Yes, ma'am.
All right. I don't have any further questions, Your Honor.
All right, thank you. Just one question, Mr. Brandenburger. You understand that you'd be waiving your right to any kind of alimony or spousal support by not requesting it now, and that you would not be able to come back later and ask the court for that?
Yes, Your Honor. I fully understand that.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of Mr. Brandenburger. The court's reviewed the file. The court finds that Ms. Brandenburger was properly defaulted and given notice of the date and time of today's hearing, which was 3:45. It's now 3:53. She has not appeared either in person or by video to contest the divorce. So the court will enter that judgment with today's date. And Ms. Canfield, anything further that we need to address for your side today?
Nothing further, Your Honor. Thank you.
Okay, thank you. That's all for today. And you're both free to disconnect at this time.
And thank you, Your Honor. Have a good evening.
Thank you.
Thank you.
Okay, we have one more hearing set for 4 o'clock. That's a non-public hearing, so the court's going to close